I'm Louis Katz. I'm a professor here at this law school and have been for many years. And I'm the moderator of the panel on closed circuit television. Let me give you some historical context and a history that I have lived and seen. 45 years ago, the Fourth Amendment was largely undeveloped, and I see everything in the context of the Fourth Amendment. However, in the period from 1964 until 1969, Americans were shocked to learn that government agencies were filming and keeping tabs of people as they entered civil rights protests and anti-war protests. And that certainly was the case here in Cleveland. Cleveland Police Department had a Secret Service division or something that had a truck parked outside of places. And intuitively, we as Americans thought that was wrong. We didn't frame it in the context of First Amendment, Fourth Amendment, but certainly it was wrong. In 1968, the Supreme Court elaborated on the purposes and meanings of the Fourth Amendment in Katz versus United States, and Justice Stewart made it clear that that which we expose to the public, willingly, unwillingly, inadvertently, we have no privacy interest in. And Katz was intended to enlarge and expand Fourth Amendment protection, but it's really been the basis for the constriction of Fourth Amendment rights and this very cramped notion of what is protected and what is covered under the Fourth Amendment. And therefore, we live in a society today which, as Dean Rawson went through the litany, that everywhere we go, we're filmed. Now, that's not consistent with the framers' notion of the Fourth Amendment, and I'm certainly not an originalist, or a concept of the Fourth Amendment that says you keep government at bay, that government butts out of our lives unless we provide government with the cause and the justification for intruding into our lives. But the notion that we are kept tabs on every place we go, and that they can individualize that and single out individuals, is just so fundamentally inconsistent with that notion. We have three speakers in the first panel who basically understand closed circuit TV, understand its implications, understand its limitations, and have had experience with the practice. I'm not going to provide extensive introductions because they're in the booklet. Our first speaker is Aileen Xenakis, who comes here as the Senior Law and Policy Analyst at the University of Maryland Center for Health and Homeland Security. And her topic is Washington and closed circuit TV. It's 2009, not 1984. Right, it's worse. Sorry. Do you want to come up here? Each of our speakers will make approximately a 20-minute presentation. And then at the conclusion, we will take questions and discussion from the panel. Welcome.
Thank you. I considered calling this How to Lose Friends and Alienate People, given the reactions of my friends and family over the last year and a half that I've been working on this project. But I went with the 2009, not 1984 instead. I work for the Center for Health and Homeland Security, and we are a research institution, but we also function as a nonprofit consulting firm. And one of our clients is the DC Homeland Security and Emergency Management Agency, where I was placed a year and a half ago to assist their senior policy advisor in drafting the regulations that were going to govern the CCTV program in Washington, DC. So today I'm discussing the various influences and the places where we looked to gather information and to try to make this the strongest and most palatable program that we could possible. The concept was to maintain safety, but also to maintain people's faith in government, and not to try to hide the ball. So as for the objectives and mission, a Homeland Security agency has slightly different objectives than your straightforward public safety officers, the police department, things like that, because there's this concept of situational awareness that goes a little bit deeper, a little bit more widespread than just a purely reactionary, crime-focused program. In Washington, D.C., it's really important that the residents' and visitors' confidence in their safety when they're moving in and around the city is maintained for economic reasons and also just for straightforward safety purposes. And as everyone knows, there are, unique risks in the district. The protection of critical assets, critical infrastructure, certain archives and documents that could not be replaced if we lost them. So the purpose is mitigation as well as a quick response. Procedurally, DC is a bit of an anomaly, so I did just want to discuss this for a moment. The process of getting these regulations passed has been intricate at best, and various different controversial issues have this same process, that the DC Council retains a lot of authority or can retain a lot of authority in the regulation process. So when they create the statute delegating the authority to the executive to make these regulations, they can keep within their rights the need to affirmatively approve these regulations as opposed to just having the agency pass the regulations and enact them, or as opposed to submitting the regulations back to council, and if you don't hear back in 30 or 45 days, they're considered to be enacted. The DC public schools have to follow these regulations, or have to follow this process also, because it's been a hot topic in DC lately. And it's unusual. It's not the first time Washington, D.C. has had some unusual procedures, but with the CCTV program, we created an emergency rule that lasted only 120 days, and we submitted it with a proposed rule. That went out for a notice and comment period. We took in those comments. We tweaked here and there. We made some serious adjustments, put it back for a notice and comment period, and so far we've had it kicked back to us from the council twice. So it's still absolutely a work in progress, and we are gathering information and trying to make this, as palatable as possible, as I said. The first thing we did was look to other influential programs. We looked at Chicago, New York, London, Baltimore to see what has been succeeding, what has been accomplished with the way they structured their programs, and what we wanted to accomplish with this program in Washington, D.C. I chose Baltimore and London just to briefly illustrate some opposite extremes. When Baltimore did their pilot program, it was very small. They didn't have very many cameras at all, and it was very narrowly tailored to a crime response and deterrence. They put most of their cameras down in an economic center at the Inner Harbor to deter crime. They used enormous signs that let everyone know that they were on camera so that shoppers and tourists would feel safe to come and spend their money, and so that criminals would be deterred. And that was, very quickly how they established their program at the beginning. And London is almost the complete opposite of that. They have the largest CCTV program in the world, 500,000 cameras. There's no concept of crime displacement because the idea is that you are always on camera. And in terms of situational awareness, in terms of getting a common operating picture for mitigation purposes, this is more of what DC was looking to do, but at the same time, we don't want to completely go off of what other cities are doing because we have unique needs. In terms of the risks, they're pretty obvious. The White House, the Supreme Court, the Pentagon. We have tourism that we want to protect from an economic perspective. We have military technology and certain documents that can't be replaced. So it's very important to recognize the need for the safety within the city. And this is all not to mention human life, of course. But in terms of the culture, there's an interesting dichotomy in terms of troubled neighborhoods really asking for more surveillance and wanting to feel safer, and politically engaged and inclined people all sort of coming together in Washington, D.C., and everyone has an opinion and everyone thinks that you want to hear it. It's a really, really interesting climate. So in order to create a program that would, sort of serve that need, not to say that you make a law based on popular opinion, but to address those needs in that climate, we had to be pretty careful about what we copied, what we tweaked, and what we left out altogether. We looked at constitutional issues. We looked at a report that the NYCLU put out that was really productive because it listed 5 things it wanted to see in regulating CCTV programs. We looked at the comments that we got on our original proposed rule, and we looked to the Metropolitan Police Department and their regulations because they did work with the ACLU and the Constitution Project, and we're currently operating under those MPD regulations until ours are approved. So first, I don't want to beat a dead horse. Obviously, the Fourth Amendment issues have been brought up time and again, but so far, no one really seems to think that there's a real problem with the Fourth Amendment here. None of these cameras in Washington, D.C. are in a place where people have a reasonable expectation of privacy. They are on public streets where anyone could turn a corner and see a police officer, or anyone else for that matter, and they've kept it that way on purpose. But in terms of this concept of privacy, people are bringing up the First Amendment and arguing that it is in fact a hindrance on whether or not people will choose to exercise their right to assemble, whether or not people will feel hindered in carrying around various literature if they know that these cameras have the capability to pan, tilt, zoom in on their pamphlet or on their group assembling. And one of the big things for the ACLU as well as for DC in deciding on what company they were going to use for which cameras they were going to purchase is absolutely no audio is on any of these cameras, and that was a huge issue for a lot of people. So as it stands now, it seems like this is completely legal, and it seems like everyone is recognizing that. And Councilmember Mendelson said that the only way this is really going to come to a head is if a citizen goes to the ACLU or goes to some other organization, the Constitution Project, and tries to bring a case arguing that this is falling within the penumbras of privacy, that there's some sort of concept of anonymity that's encompassed in privacy. So far we don't have an answer on that. The NYCLU report called for 5 specific things. This was in 2006, and it really drove how we drafted our regulations, and we aimed to be really sensitive when we were drafting these regulations. We didn't want to hide the ball. We didn't want to come up with anything that was so gung-ho that people felt not safe, but in fact violated. The first thing they called for was a scope and purpose to be very narrowly defined, very clear in the regulations, and to have yearly audits of the program to make sure that people were in fact adhering to these regulations. They called for needs assessments to be done within the city so that people knew exactly what the goal was. As for public notice, This is something that the HCMA regulations took into consideration, and also the MPD regulations, the Metropolitan Police Department have in the regulations that we're using right now. We have a website where people can quite literally look up exactly where the cameras are going to be before they leave the house, so there is no reasonable expectation of privacy, so that people know exactly what they're dealing with. And they do put out for public notice anytime they are ready to put a new camera somewhere, and they put the location and people can comment on that. And it's really quite a thorough process. As far as training and supervision of personnel, this comes back to the concern that people would misuse the program. Overwhelmingly, the sentiment has been not one of opposition to CCTV, but one of opposition to the misuse of CCTV. No one likes the idea of people sitting in a room and being able to zoom in on them just because they're bored. Councilmember Mendelson has said more than once in the Washington Post that the concern is that a bunch of, bored police officers or people detailed to the Fusion Center at HCMA would be zoning in on girls with short skirts. I can't tell you how many times I've heard that phrase. It seems to be his primary concern, although I think other people are a little bit concerned about the literature and the right to assemble and things like that. But it keeps coming back to the girls in the short skirts. In the HCMA regulations, we were very explicit in lining up a company to train the people who would be viewing these cameras, and defining exactly who would have the authority to be the supervisor, what kind of training that supervisor would have. A lot of the language in CCTV regulations talk about extenuating circumstances or exigent circumstances, and people's arguments come from what does that mean, and under which circumstances are we going to let people decide this is an exigent circumstance. We can record, we can zoom in, we can go back and examine this more closely. So that has been very explicitly lined up in the HCMA regulations. It's a little bit less explicit in the MPD regulations, but the sentiment is the same. As for storage and retention, this is a huge issue for a lot of people, and we have been very, very clear about a 10-day cap unless there is specifically criminal evidence contained on the tapes. It seems to have placated a lot of groups. The Constitution Project seems satisfied with it, and it's what the NYCLU called for in its report. So we haven't been meeting with too much resistance from council on that issue. And prohibitions and penalties, this is just really to put teeth into the audits and making sure that people are in fact following these regulations to ensure that people understand quite how damaging misuse of this technology can be. This is an example of the website so that you can look up before you leave your house exactly where these cameras are going to be, who owns the cameras. These are, at the top of the list, the public schools. But we've really tried to be very sensitive to these needs and to try to draft the regulations and obviously implement the regulations as such, to make it as comforting as possible so the people do feel safe and they feel like there isn't as much of a terrorist threat, or if there is one, that we can respond to it without feeling victimized or feeling like their civil liberties are being compromised by the program. When we put out our proposed rules, we got comments back from the ACLU, from the Constitution Project. We got a lot of feedback from council and resident feedback as well. When we put these out for comment, we wanted to address all of the different groups, and the ACLU's primary issue was parents and the concept of their children being watched from the public schools. In this Fusion Center, they had this vision of like the Dark Knight, where at the end you see the whole room of all the different video feeds, and it freaks people out. So I think that people are really trying to address that and trying to make it as understood as possible that's not how it is, that this is very regulated, that there are supervisors taking that into consideration and no one is watching these children. You know, in the case where maybe a fight may break out, if it gets violent, if there are sort of weapons brandished, then they can pick up the phone, call MPD and have someone there quickly for safety purposes, but no one's really watching children. That was the primary testimony submitted from the ACLU during the hearings. The concerns coming from the Constitution Project were largely the same as in the NYCLU report, so we had already largely addressed them. And in terms of counsel, we've gotten a lot of feedback, political feedback within the context of the hearings as well as within the Washington Post that we find out about afterward. And we are addressing that as much as we can, and that's why it's still a work in progress. We're trying to get those regulations passed, and one of the strongest things that we have going for us is that the neighborhood associations in the more dangerous neighborhoods are calling for more cameras. They are really fans of this technology, and they're on board, and they want to see this. Obviously, they want to see it regulated closely, but they also want to see the cameras being put to good use so that people do feel safe when they are moving in and around their own neighborhoods as well as in the economic centers. So for the HCMA proposed rule and for the MPD regulations, we see a lot of overlap. And although we're currently operating under the MPD rules, I personally feel like like the HCMA proposed rule is superior because I helped to write it. But we really do try to be as explicit as possible, and we try to be very sensitive to the needs that people are expressing and to the concerns that people have, because as I said, the goal is to maintain safety, but also to maintain people's civil liberties and to maintain the faith of people in government. And it's necessary to have these civil liberties as well as safety if people are going to have faith in their government. So it's a work in progress, and I'm looking forward to hearing what everyone else has to say today so that I can bring back maybe certain ideas that are going to strengthen the regulations and help it to be the best program that it can be. I'm sure people will have questions, but I don't think this is the right time for that, correct? All right, thank you. And this is my contact information in case anyone would like to contact me later. Thank you.
Thank you, Aline. I don't think I've ever felt more safe or more naked.
Image just boggles the mind.
Yeah, I just can't wrap myself around this whole concept, but it's what people want, I think. Our second speaker today is our Associate Dean, our Associate Director of the Cox International Law Center, a co-director of law, technology, and the arts, and a professor of law at this law school. Jackie Lipton has lived under this system in England. I guess you didn't have to look up on the web where the cameras were because they're everywhere. 500,000 cameras. Isn't that amazing? That's scary. Jackie's topic is digital multimedia and the limits of privacy law. So, Professor Lipton.
Thank you. I'm just going to have to fidget with the technology here to pull up my own PowerPoint, which I don't know where it is. So I'll just start by thanking my colleague Bob Strassfeld, thank you very much, for inviting me to speak at this symposium. It's a terrific symposium. I am a bit of an interloper here because, in fact, my exposure to CCTV is, as Lou Katz said, I lived in England for a while where there are a lot of CCTV cameras, but my actual work has been not so much on national security, not so much on CCTV, but more on privacy law more generally in the civil context recently. And I've been recently very interested just in the notion of privacy in video files, in audio files, in digital multimedia files. So my work is more generically in that area. And I was thinking, well, what can I really contribute to the discussion here today? And one thing that I am interested in is doing a bit of a case study of the EU Data Protection Directive in the context of these kinds of files, because these are the files that the CCTV cameras pick up, and as Eileen said, sometimes it can be with audio and often it can be without audio, and that makes a difference to people what is being recorded about them. But why I find the Data Protection Directive an interesting case study is it is, in the world, one of the most comprehensive attempts to protect individual privacy, and the American law has not been as comprehensive in this regard. It's been more sectoral, it's been more piecemeal, it's been more state by state. So I thought that in this context it might be useful to look back on the operation of the directive over the last 14, 15 years. It was implemented in 1995, and see what its limitations are with respect to these kinds of data files about individuals, video, audio, multimedia files, because we might learn something in the States about how to proceed with regulating the collection and the dissemination of this kind of information in these kinds of formats, if we can look at what's really happened in the EU with the experience under the directive. And over the last 14 or 15 years, there have been working groups on the directive looking specifically at how it applies in the video surveillance context, how it applies more recently in online social networking, because that's another example where you have a lot of video and multimedia files disseminated without people's authority or consent necessarily. So that's what I'm going to do for my 15, 20 minutes. I'm going to sort of walk through what the directive intended to do, what its shortcomings have been, what some of the reviews of the directive have suggested should be the next steps, and then end up thinking very briefly about how that might inform the sort of work that Eileen is doing, how that might inform where the US takes its law. And I think, one thing the recent 2009 review of the directive came up with is there does have to be more global cooperation. There simply does have to be more stakeholders involved in the discussions of best practices, and I think that's something that the US needs to be mindful of. So in 1995, the EU directive was implemented with early digital technologies in mind, obviously, because it's the mid-90s. So the main concern is really with text-based data aggregation. It's really with, at the time, the concern that governments and businesses could be creating large profiles of individuals in text formats, in these large searchable text-based databases. And that was really what they had in mind, largely because the technology hadn't really developed to the extent that we were hugely concerned about video and multimedia files. So what the directive did was it basically protected what they called data subjects from privacy incursions by all manner of parties. So unlike the US law, it's not aimed at particular sectors or particular groups, and there's not really a distinction between government and private data collection. It's just anyone who collects data about private individuals has to comply with the provisions of the directive, and they have to be implemented into the national laws of all of the EU member states. So what the directive does is it creates limitations on what entities can do in terms of processing data generally, personal data generally, and I'll talk in a minute about the definition of personal data, and also more stringent restrictions on the collection, dissemination, processing of sensitive personal information, which is things like health, political views, sexual preferences, racial and ethnic origins. So there's special protections, more stringent protections for particularly sensitive information. And it also creates general comprehensive rights of access in data subjects. So any information subject is entitled under the directive to know that information about them is being collected and to have access to the data and to check it for its accuracy. So it's global, it's comprehensive. It is aimed very much, or the drafters very much had in mind these sort of large-scale database compilations of personal data. The objective of the directive and the definitions are set out, and I'm sorry this is going to be lots of text on these slides because many of you won't be familiar with the actual provisions of the directive. And because I'm both astigmatic and have just got bifocals, I've noticed that there's typos all over the slide. So if you're bored with what I'm saying, you can play a game of search for how many typos. I've found 2 or 3, but I'm sure there's more because I just can't see anymore. So you know, it doesn't matter if I'm being surveilled. I can't actually surveil anyone because I can't see. But the objective of the directive is to protect the fundamental rights and freedoms of natural persons with particular respect to privacy in the processing of personal data. And processing and personal data are terms that are clearly defined and broadly defined in the statute, and I'll show you the definitions in a second. And this also complies with Articles 8 and 10 of the European Convention on Human Rights, which Article 8 talks about privacy as a fundamental human right. Article 10 talks about expression as a fundamental human right and that tension between free speech and privacy, and I'll get to that in a second. There are 3 significant balancing acts then that the directive tries to do. One is the freedom of expression, copyright and freedom of expression, and you see that set out in Article 9, that the right to privacy does sometimes have to give way to free speech, as indeed it does in the United States. The difference here, of course, is that free speech is a really express constitutional right, and the right to privacy is implied in various provisions of the Constitution, but it's not an express right. So it often means when commentators in the States talk about privacy, they often talk about privacy having to give way to the stronger free speech right, although many commentators have also questioned that and said, well, both privacy and speech are aspects of individual autonomy and should both be protected. So that's a debate in the States, but in Europe there are clear express constitutional protections for both rights. 2 other exceptions in the directive to when you might be allowed to process personal data without getting into trouble under the directive. The personal or household use exemption, which probably doesn't particularly apply to CCTV, but does apply to some stuff that goes on online social networks, for example. And public security and defence, which might apply to some CCTV, but not all, because as we know, there's just millions of these cameras in England is a great example, as we've heard. And I think the figure I have later in my slides is that there's 1 camera per 12 citizens in England. So it's, you know, a phenomenal amount of CCTV cameras. So in terms of how the directive conceptualises personal data, the definition is broad, and I've set out the main bones of it here. Any information relating to an identified or identifiable natural person, and then it tells you who an identifiable person is. And with particular reference to factors specific to physical, physiological, mental, economic, cultural or social identity. So really carefully protecting aspects of an individual's persona. Recitals to the directive do contemplate, even though the directive is drafted in the 90s very much with text-based files in mind, that sound and image data is intended to be contemplated, although the drafters didn't really know how that would play out. They just could see that there would be in the future much more of a capability of data collectors to deal with multimedia files. So recitals 14 and 17 both contemplate that the directive is intended, this definition of personal information will include data in multimedia formats. Recital 17 in particular and Article 9 specifically note that with respect to that kind of data, there's going to be a difficult balance with free speech journalism type issues and with intellectual property rights, because those are 2 areas in which audiovisual data is very important, and the drafters could see that in the 1990s, that journalism does rely on putting photographs in the media, video on the news. Audiovisual data is going to be very important there, so even though it can infringe a privacy right, there may be many circumstances in which the people have a right to know and you want journalism to be able to use it. And IP rights as well, because obviously copyright in particular, photographers, artists, audiovisual type data is implicated in that balance between the property and the privacy. So that was contemplated back in the 1990s. No one was really sure how it would play out, but certainly the drafters of the directive did contemplate more than just text. And the definition itself is not limited to text-based records. It was just implicit in what the drafters were thinking about at the time. The directive put in place this mechanism, which has been used a lot over the last 14, 15 years, that the operation of its provisions can be reviewed from time to time by working groups. So in Article 33, it was contemplated that there would be ongoing review of how the directive was working. There would be overarching reviews of the whole directive, and there would be intermittent reviews of specific aspects of the directive. And again, in this provision, there was specific reference to sound and image data, to these audiovisual multimedia records, because the drafters knew that the technology was going to develop and enhance, and that they had to have provisions in place to look at how the directive was impacting on these new kinds of technologies. Over the years, however, there were no specific proposals made on sound and image data. It was looked at in various contexts, and on the slide I've noted some of them. So there have been a couple of working party reports examining the operation of the directive to video surveillance in particular. They came out in 2002 and 2004. These are all available online. There was a recent examination of the directive in the context of online social networks, and that talked a lot about audiovisual data, because people share photographs and audio files, multimedia files, things they record on their cell phone cameras of their friends. And also in the context of a report in 2007 on how that broad definition of personal data should be conceived, that also looked at the question of the format of the data. And comments were made, I'm not sure if I have this on the next slide, or yes, I do. Comments were made in that context that sound and image data clearly are part of the concept of personal data, and that was what Article 33 was getting at, and that's what the broad definition of data protection was getting at. And questions arose, I don't think I put this on a slide, but I think it comes out of this report as well, about the extent to which you should actually consider some of this multimedia data as automatically coming under the sensitive personal information category, not just the general personal information category, but the highly protected sensitive personal information category, because particularly visual data may be more likely to let someone know what your ethnic origin is. It certainly would identify your gender, could identify your political affiliations if you were photographed at a political rally or something like that. So some EU countries actually do specifically protect all video data in their national laws under the high level of protection for sensitive data, although that's not the official position that the EU takes. The EU says, well, it might be sensitive information, it might not, but some countries do have special national provisions in their domestic laws for this kind of data as being particularly sensitive, or just having the potential to be particularly sensitive. In terms of what a data collector does and what sorts of activities are regulated, again, this is a fairly broad concept. Article 2B gives you a definition of data processing, and like the definition of data, it's very broad. Processing, what is regulated under the directive includes any operation which is performed on this data, including collection, recording, organisation, storage, adaptation, alteration, retrieval, consultation. You can read the rest of it, making available, blocking, erasure. Now that clearly covers stuff that happens with CCTV cameras, provided that the concept of data includes audiovisual data, which it seems to. The definition of processing clearly contemplates what goes on with video surveillance. So theoretically, at least, anything that happens on a CCTV camera is regulated by the directive, which means that you shouldn't really be processing this information without making sure that the data subject has access to it, the data subject can check its accuracy. If it reveals sensitive information, you actually need the subject's consent to do anything with the data at all. So that's probably, well, it's definitely not complied with in practice. I mean, this directive is very difficult to enforce, so in some ways maybe it serves more of a communicative function than an actual enforcement function. But it does theoretically apply, subject to the exceptions, of course. And so these are the 3 exceptions I referred to earlier, many of which will not apply to a lot of what goes on with CCTV cameras. The sort of the journalism exception, the free speech exception, well, if you recorded something on a CCTV camera, it got into the hands of the press and then they used it in the public interest, that may be perhaps accepted, that may be an exception under Article 9, but the initial recording without consent would theoretically be infringing of the directive, or may well be infringing. The personal or household use exception, this is a really interesting one, but not that relevant for CCTV. This is the one that says, well, if you were only processing data for kind of personal or household use, you're not in breach of the directive. This is actually much more relevant to online social networking. Where do you draw the line between something that's really personal between friends and something that's been disseminated all over the internet on Facebook? And I can talk about that in Q&A, but I don't need to talk about that now. The authority, to the extent that the European Court of Justice has talked about it at all, has basically drawn a line kind of like our reasonable expectation of privacy test. They've kind of said, well, if it's a public disclosure, which means it's just generally disclosed on the internet, that doesn't come under the personal or household use exception. But if it's a limited disclosure to a limited group of friends on the internet in a closed network, that may come under the personal or household use exception. But the lines for that are actually quite blurry. But that's not so relevant to CCTV, that's more online social networks. Public security and defence is the exception that's probably a lot more relevant to this discussion. And there really hasn't been a lot of specific testing of the directive's provisions in this context. There was a working group fairly soon after 9/11 in 2001 talking about the need for a real careful balance between applying the public security exception and protecting the privacy of individuals. There was a real concern about an overly strong knee-jerk reaction to 9/11 that might impact on the civil liberties of private individuals. They were watching what was happening in the States, and it's a short working group opinion that basically just makes that point, that although there is this public security defence exception to the operation of the directive, people have to be very careful about still protecting privacy. And again, but there's not much practical decision making on that. That was just a policy paper put forward by the people reviewing the directive. So we've really talked about how some of this then plays out in practice, and Eileen's talked about a lot of this, and I don't have to really go on about it in great detail. A lot of CCTV cameras, England is the poster child for... I lived in Nottingham, I lived in this tiny little town in the Midlands, and there were cameras everywhere and you couldn't do anything, and it was just... But you get used to it, you sort of figure it's about security, whatever. But, clearly, despite these very stringent laws, you still have this situation. Some of the people, and I've basically, what's on this slide, I've just got from newspaper reports in London, that some of the types of video surveillance probably don't come under the national security exception in the directive anyway, because they're for protection of protection of property, or perhaps detection, prevention of crime, and that sort of thing. So that is going to be subject to the directive. That's not going to come under sort of a national security defence. But again, there've been reports on this, and the contours aren't really clear. Comparing that very briefly, I don't know how I'm going for time. I assume I've got like 2 minutes. Sorry? I'm out. Okay. So I won't talk about the US because other people will do that later, but what I will do is say that what we've probably learned from the directive is, and this is certainly the May 2009 review of the whole directive, said, well, we need now a global cooperative approach. The directive has been good, but it's limited. We have fuzzy boundaries with the new technology, and we're not globally working with other countries. We need to focus on principles and best practices rather than nuts and bolts laws. Government and business needs to work together. We need a concept of privacy that encompasses all these different kinds of information. And we need to be able to really, I can't answer this question, better people than me have tried, but we really need to figure out what we mean by reasonable expectations of privacy with CCTV cameras and virtual spaces. I'm very sorry I went over my time, but I look forward to your questions. Thank you.
Thank you, Jackie. Jackie's message is you get used to it. And I guess we all are. Our final speaker on this panel, Ms. Michael Vaughan, is the policy director of the British Civil Liberties Association, an adjunct. I mean, a real civil liberties union. British Columbia, not Britain. Thank you. And, you know, security at the Olympics is a big issue. I'm sure the International Olympics Committee was never as comfortable as they were since 1936 as they were in Beijing for the 2008 Olympics, where everything was security and order. How is that going to work in a country that's really concerned about individual and personal privacy? And Ms. Vaughan is going to talk to us about CCTV and the 2010 Olympics. Thank you.
Thank you.
Now, I said nice things about Canada.
Yeah. Oh, well, one of the things I'm going to be addressing in talking about spatial tactics and political strategies in CCTV in 2010 Olympics is the question of whether or not we in fact do have a reasonable expectation of privacy even in public places. And whether this question of has the constitutional door been slammed shut is actually true. I'm going to be referencing primarily Canada, but I think this has implications for America as well. So there are many aspects of CCTV that are legitimately contested and that illustrate various nuances. We have, for example, research that would suggest that while cameras in a given context may cause fear in some people, they give reassurance to others. There does not seem to be, however, any contest about whether or not cameras aimed at protesters are there for the benefit of the protesters. Cameras aimed at protesters are not there for their safety, nor to facilitate their use of public space. Cameras situated primarily for the purposes of capturing expressive activity, and this would certainly come under Washington, D.C. would have many places in which that is indeed so, are not there for the speakers, but are in fact deployed against them. There's really very little support for any other view, as indeed even the police have to concede. That is the point when their own ox is getting gored, as we saw in 2006, when the New York Police Union sued the city of New York for photographing them and videotaping them when they were off duty at a public demonstration protesting the pace of their contract talks. The police union claimed that the heavy-handed surveillance tactics, which of course are routinely used for other kinds of protest, anti-war protest, anti-poverty protest, were a violation of the police officers' rights to free speech. Now clearly, the visual surveillance increasingly being used to monitor public expressive activity has a chilling effect, and that is almost assuredly one of its aims. Visual capture makes us much more knowable in public space to public authorities and erodes our public anonymity. Our public anonymity is, of course, never a case of being unrecognizable. We need a more nuanced approach to this. As Alan Weston puts it, it is our ability to be able to blend into the situational landscape. The loss of public anonymity affects freedom of speech, freedom of assembly, and our public politics more generally. So, CCTV surveillance in the context of public demonstration affects who can say what, how, and where. And I'd first like to discuss this from a legal geography perspective as a spatial tactic. using the upcoming Vancouver Games as my main reference. And I'd also like to comment on the political strategies that we're seeing. So, first off, legal geography. What sort of a thing is that then? Legal geography deals with anywhere that space intersects with law, and it highlights the fundamental importance of spatial contexts in law. For example, we actually think about law, we use spatial concepts all the time. Property, borders, jurisdictions, even this fundamental distinction between public and private is a spatial concept, and it's the foundational principle of our rights theory, arguably. So legal geography tries to unpack the assumptions about space that are embedded in law and understand the connection. What a spatial tactic is the use of space as a strategy or a technique of power and control. So mega events like the Olympics provide an embarrassment of riches, in fact, for students of spatial tactics, particularly those tactics dealing with the policing of public spaces and the control of expressive activity. The best primer, if you're interested on spatial tactics and their relationship to public speech in the US context, is a book called Speech Out of Doors by legal scholar Timothy Zick. Zick describes how space is needed for democratic discourse. And that space he describes as the expressive topography. And he talks about how it's been dramatically reduced by the steady erosion of public space through privatization and development, a vast array of spatial tactics of containment and displacement, in addition to First Amendment legal doctrine that views space as fundamentally abstract and fungible, i.e. you don't need to demonstrate over there. How about 15 miles away? That'll be fine. Space is fungible. Now, most people's understanding of the importance of place in terms of their rights is pretty crude. We typically use the language of ourselves as rights-bearing individuals. It's implicit in this idea that our rights go where we go, at least insofar as we're in our own country, for example. This is why people are so often stunned, in my experience, to discover how ludicrously Byzantine and non-intuitive the geography of rights actually is. My favorite example, and you can see my bias on this, my favorite example of trying to understand the geography of rights in your everyday life is a very memorable moment in my own life when the then chief of the Vancouver Police Department was taking part in a public campaign soliciting donations for the Raise a Reader literacy campaign, totally wonderful campaign. And he sees me walking down the street, and I happen to be a very vocal opponent of our provincial anti-panhandling legislation. And so Chief of Police sees me walking down the street, and following my line of vision to the nearby bus stop, he realizes that his proximity to this bus stop locates him in a no solicitation zone, as per the new Safe Streets Act. Graciously, I did not press charges. The point is that we have very little understanding about how the geography of rights works and how imperative place is to our rights. Place is where power and rights are contested. And the more highly securitized the place, the less likely it is to be a space of spatial contest. Securitization, and in particular visual surveillance, has become a commonplace spatial tactic. The UK, of course, has already been referenced as the cake taker regarding public surveillance by CCTV. However, many cities are following suit. Securitization through visual surveillance is often cited as a technique for displacement, i.e. to discourage the supposedly criminogenic other who are the targets of broken windows, inflected policing. But much less has been said about CCTV, the presence of it, at traditional sites of assembly for public expression and contest. Or for that matter, at non-traditional sites that are designed for protest and surveillance, like the already notorious free speech zones currently being built for the 2010 Games in my city. And I use the term built advisedly. As Philip Boyle and Kevin Haggerty have pointed out, surveillance architecture is not a mere byproduct of hosting the Olympics anymore. It is an actual deliverable. It is explicit legacy. Just how many CCTV cameras are coming to Vancouver for the Olympics is not known to me, nor is it known to, I think, anybody. Academic papers have been written on this very subject, the impossibility of getting a straight answer to this question. But since security logic does not incorporate any sense of proportionality, the assumption is that the only factor that's actually limiting this is budget. And the security budgets for the Olympics have been increasing by leaps and bounds. Despite the extremely witty and droll initial assessment of $175 million for Vancouver's Olympic security, the security costs right now are ballooning up to close to $1 billion, security alone. CCTV installation at mega events, increasingly extensive and elaborate, and increasingly repurposed, of course, for mundane policing purposes post-event. We know that many of the cameras that are going to be used at in Vancouver for the Olympics venues themselves and so-called live sites, which are securitized public gathering and entertainment sites in the city center. CCTV at Olympic venues, officially and live sites, could very well capture expressive activity. Of course, if anybody unfurls a banner, it says Free Tibet. It will certainly have a chilling effect on expression in these so-called clean venues that are supposed to be free of propaganda. Just by the by, clean venues may fly as a legal concept, i.e. we don't allow propaganda in here. If they're private sector, we already have a constitutional challenge to that in the public sector in terms of the zoning that's going on in Vancouver. But the CCTV in the Olympic context that is primarily meant to capture expressive activity is, of course, that's going to be aimed at the free speech zones, or protest pens, as the rest of people refer to them. Protest pens very clearly and blatantly an infringement of free speech rights. In the bizarre semantics of the Vancouver Games, these designated protest areas that the security authorities tell people are, of course, voluntary, because they are. And that being true, it actually begs the question, who would volunteer to be penned? We have to assume this is either people who don't know their rights, who don't know that they can freely have expressive activity in almost any public space, so therefore they are easily corralled into these contained areas, or people who actually believe the security authorities' line that these protest pens constitute an enhanced service, something along the lines of the police having scoped out all the good venues, location, and helpfully provided those for the convenience of the protesters. You'd have to believe one of those two things. The Olympic Security Unit, the ISU, has confirmed that there will be protest pens, and they say that they will give closer access to the sites of the games than the protesters could achieve in public space elsewhere. What they haven't said, but we know through other means, specifically we know through the timelines for the venue construction, that some of these designated protest zones are clocking in at 8 days apiece, estimated for them to be built. So obviously there's a lot more than fencing involved. We strongly suspect that most of that build will be surveillance architecture. CCTV, in conjunction with the segregation of the protesters, not only monitors protest messages, facilitates identification, but it brands the protesters as dangerous. It is expected that some of the grotesquely stigmatizing designated protest zones that have recently been created in the US in certain contexts, like these zones, the protest zones in Vancouver are very likely to be largely or almost entirely unused. Even if the sites are not used at all, they will reduce the expressive topography available for protest and stigmatize protesters more generally. The element of containment along with the highly visible surveillance equipment is essentially the architecture of fear. Even if it sits empty, the message is sure to get media coverage. A very expensive messaging, mind you, that the taxpayers are paying for, with all these high-tech security props eventually being redeployed in domestic policing. And this naturally doesn't mean that, or naturally, I'll just say this because I think it's relatively obvious, it doesn't mean that protesters who don't use the pens will be free of surveillance. Security officials will, of course, be able to hold, or in some case, if you haven't seen them already, new gizmo alert, wear body-mounted cameras. So protesters who avoid the protest zones are not going to be free of surveillance because they're likely to encounter mobile surveillance elsewhere. But the protesters can themselves also hold cameras. And they are more likely to hang on to those cameras for their own purposes, like police accountability, if they're not penned in. So avoiding the protest zones is actually more realistically an attempt to equalize the surveillance equation rather than eluding it altogether. But there are other reasons to avoid those zones, including resisting the stigmatizing implicit message. So protest zones as a spatial tactic to contain and stigmatize dissent are not dependent on CCTV. But I would argue that CCTV is an important feature of this particular spatial tactic. Increasingly deployed at those sites where its primary function is to capture expressive activity. And this is increasingly true, that CCTV is increasingly found in places like the traditional speaker's corner of the public park or whatever the functional equivalent is. I suggest that even a lone camera in that context is proxy for the formal designation of that public space as captured by the authorities. In other words, a de facto protest pen, undermining the function of that public space as a stage for free assembly and branding the speakers as dangerous. So let me say a few quick words about the politics of CCTV, which are much in evidence at the Olympics. I've already alluded to how the importing of CCTV for mega events essentially endows the host city with surveillance architecture and infrastructure, while sidestepping the political grief of justifying the expenditure. Cameras just come with the event, and so they're left behind as legacy. This is one aspect in the Olympic context of the great CCTV shell game, recently discussed in a paper by Laura Huey, who's on a panel later. Through a Freedom of Information request, Dr. Huey was able to discover that, as absolutely was expected, the Vancouver Police Department were in negotiations for the Olympic legacy cameras. The details of those negotiations are still vague, but it's very interesting to look at how the fact of those negotiations has been they've tried to keep secret. They've tried to obfuscate it. Privacy advocates making a very similar FOI request of the same police department were originally told that the scope of their request was impossible to comply with, couldn't do it. And then the police department very helpfully said, you need to narrow the scope of your request so we can get back to you within a year and a half. And in order to do that, we suggest that you look over here at this department. And then after months and months and months and months, you can guess what happened. The response to the privacy advocates' Freedom of Information request was, quote, no records responsive to your request. Now, they didn't actually write the words ha-ha in the margins, but it was certainly there by implication. And this sort of extremely blatant manipulation in order to foil resistance to CCTV is a sadly common one in my jurisdiction. The city of Vancouver, for example, was absolutely adamant that the CCTV that they were going to commandeer for the live sites, these entertainment zones, was going to be temporary. And the insistence on the temporariness became more and more shrill as privacy advocates such as myself pointed out the incongruity of the city building a permanent control center for their supposedly temporary cameras. Now, finally, the city, after literally months of this, was forced to admit that, the language of temporary didn't mean temporary. It meant mobile. Because they're virtually the same thing if you look in the dictionary. And the mobile cameras, when I inquired, of course, permanent mobile cameras is what they had actually meant by the language of temporary. Now, it is one of the great mysteries of the politics of CCTV as to why police and politicians will essentially debase themselves with these shoddy and unethical tactics in order to get their hands on CCTV, when the vast majority of evidence shows that CCTV has little or no efficacy as a security mechanism. A trend that I suggest is worth investigating in this context is how CCTV shows up usually as a kind of free prize. The Olympic legacy cameras, clear example of this. But much of the proliferation of CCTV in the US is the result of the lure of the funding of Homeland Security. And we see a very similar mechanism in Canada, where money is made available through special grants by federal and provincial governments that are essentially for cities' municipal transportation systems to get CCTV. So not only is there a general failure to debate the merits of CCTV in a given community, which is what you would expect in a democratic process, there is no cost-benefit analysis ever, because the costs are essentially laundered through a different part of government. So, incidentally, this is a very similar movement, I just have to say this quickly, evident in the surveillance of personal health data, right? At least where I come from, where the federal government is issuing these grants to all the provinces to get surveillance of health data through centralized electronic healthcare records. That money would be probably not allocated for those purposes to the health authorities that are looking to maintain services, get staffing, MRI machines, diagnostic machines. But the simple fact that that's what those funds are for, as opposed to anything else, makes this a done deal, because the political equation, like the CCTV equation, is not this project versus another, well, perhaps more important or more meritorious project. The equation is free money for the initiative or no free money, which I'm guessing is why you see some of this incredible impetus for people to go to the wall for this. Although, of course, there are true believers in safety purposes and various other things, not to minimize those. But there's a huge kind of internal momentum here because the money is for nothing in terms of this mechanism that I'm describing, which I call an insidious form of internal policy laundering, and the primary means of quashing any meaningful debate on CCTV and other surveillance systems within the context of the communities that they're actually going to be deployed in. And a final note on the politics of CCTV, I've got my eye on the clock, is part of the wonder of what's happening in Vancouver, my city, is the brazen illegality of so many of the public control measures that are being demanded by the International Olympics Committee. And as I've mentioned, we already have constitutional challenges to bylaws that the city has enacted, for example, that prohibit non-celebratory signage. I'm not making that up, right? Non-celebratory signage can be prohibited in certain zones. But there's another kind of wonder that's much subtler in this context, and that's the idea of many of the absolutely taken for granted, not questioned, seemingly completely acceptable security measures for the Olympics, that also, in point of fact, if you actually look, might not be legal either. Wes Pugh and Rob Diab recently published a paper on how in Canada, in fact, there is no statutory or common law authority for the police to create special securitized zones or security perimeters. None. Now, many people would argue if you're going to host an event like the Olympics, you've got to have these kinds of powers. But the point is, there doesn't currently appear to be any. And similarly with CCTV, there are going to be public spaces that are going to be blanketed with these things. Virtually nobody is surprised by that. And yet, in the Canadian context, there's very little case law which would guide us in determining if or when such sweeping public surveillance is permissible under our Constitution. The practice makes it seem like it's all settled, but in fact it's not. Now, I oppose going after these cameras in the Olympic context because that's going to be a sure loser, guaranteed to make bad law. But what I suggest is the legacy cameras could be ripe for challenge. The ideal challenge is almost certainly aimed at cameras primarily situated to capture public expression, so that the challenge is brought not only on the grounds of right to be free of unreasonable search and seizure, the privacy implications, but also on freedom of expression and freedom of assembly. And I think that the use of CCTV as a spatial tactic to control or chill public expression is ripe for both legal and theoretical exploration. Those are my comments. Thank you.
Thank you. We're neither safe nor free. How comforting. We're going to take questions at this point. The three speakers have given us a lot of food for thought. Please raise your hand and then wait for a microphone to get to you so that your question can be recorded. Right over here, please.
Am I on? Can you hear me? Okay. I particularly had a question for Eileen. Since you raised the constitutional issues of the First and Fourth Amendment, it occurred to me that there's also some questions of the 14th Amendment under equal protection. I'm actually from DC, and some of the controversy that has been apparent to me is that some of these cameras have been placed in what you refer to as troubled neighborhoods as what I know to be Black or Hispanic neighborhoods, if you can comment on that.
Thank you for asking that. I anticipated the question. In terms of, it's not the first time I've heard it, but in terms of concentrating any cameras anywhere, because the purposes of this program, because the main purpose is situational awareness, because these cameras were really trying to go into action before the inauguration, we didn't concentrate the cameras there. Actually, the neighborhood associations in Ward 8 specifically have been asking for more cameras there because there is quite a bit of public space with public housing, and people want to feel safer in their neighborhoods. So in terms of targeting underprivileged communities or any sort of a racial or ethnic group like that, we haven't gotten too much feedback on that because the communities and the neighborhood associations where, statistically those minority groups are concentrated are in fact advocating for the program. So it hasn't caused as much of an issue that I initially thought it would be causing. I'm coming from Baltimore as a contractor down to DC, and the first time they floated these ideas out to me, that was one of my initial thoughts also. But it's been really interesting. The primary concern has been focused on this idea of privacy and the First Amendment, and it hasn't been so concentrated on, maybe targeting poor people or however, obviously people are going to try to frame it in the most offensive way possible because a lot of people feel very offended by that, and feel very concerned that people are being targeted or what have you. But in terms of our program, it helps that it hasn't been concentrated there. It helps that the goal has been to gain situational awareness around, the White House, the mall, things like that, where there are specific targets and not just, specific neighborhoods. But the other thing about that is the HCMA Fusion Center doesn't have access to the MPD cameras. And MPD has their own center where they view their own cameras, and no one else has the right to view those cameras. So I don't have as much of an inside baseball view on that, because I just haven't been privy to it.
NPD?
Metropolitan Police Department, I'm sorry.
Okay. I misunderstood. Thank you. Do we have any other questions? Yes.
So I've tried to think about some other instances where space has been transformed in a significant way. So the obvious example is enclosure, which, going back several hundred years, which dramatically changes the use of public space by making it not public space. And then there's Cleveland's gift to public safety, the invention of the traffic light. The one has changes the world in an important way. The other changes the world as well in a much more benign way. And I guess my question is, it's been said here more than once, well, we get used to it. If you look to the future, is this closer to enclosure, or is this closer to the invention of the traffic light? How do spaces change in 20 years by virtue of the increase in the number of cameras all over public space?
Well, I think it's a little broader than what I can speak about in any capacity of having particular expertise. Certainly, urban geographers would suggest that the last 20 years has seen an increase in de facto zoning that segregates people out of certain places in public. And there's been a series of mechanisms that I'm terming legal spatial tactics that have seen that increase. So whether, is that benign? I suggest it's not. This is just merely one of them, alluding to so-called Safe Streets Acts or panhandling regulations, or just there's a raft of the hyper-regulation of public space, including the aspect of surveillance, is clearly having a de facto social sorting effect that I don't believe is benign.
Could I actually briefly add to that too, that it's not just the increase in the number of cameras, it's the technological advancement, because the cameras are getting smarter and the cameras can actually work out more stuff about you with artificial intelligence now. So there's really two aspects to that. So if I were going to attempt to answer that, and I'm not a legal geographer, I would say it's more like enclosure.
And wait till we attach retinal scanners to them as well. Do we have time for one more? Ted?
I asked this question of Michael Vaughan from the perspective that I have a daughter and son-in-law and 3 grandchildren who live in London. And I haven't heard them really complain about the cameras in London, except when they get caught on a congestion charge on that. But my question is, England has been long the citadel of free speech, and has Hyde Park Corner, have the speakers at Hyde Park Corner been inhibited by the amount of cameras that are now, obviously they are panning all over Hyde Park Corner, which was once the great soapbox of the world. Has that been reduced? And the second aspect is, if you have these cameras, but you have the kind of directives, as Jacqueline Lipton has been talking about, as to the use of the information, does that really, doesn't that to some extent protect the speaker or the demonstrator or whatever it is in the space?
I'm gonna go last question first. One of the things that I'm increasingly thinking would be a great project for my lifetime is to audit systems to find out how often they are actually used and how often they actually audit anything at all. The idea that regulation typically is we'll audit our surveillance of you, and that will be the privacy protection, right? There's no notion here that privacy can only be protected from the front end. So audit trails are increasingly being spoken about as if they are privacy protection, and of course they aren't. Your privacy's already been breached if the audit trail is finding the breach, right? So it doesn't actually protect your privacy. It's supposed to find out who's breached it. So I'm concerned about the idea that regulation is just going to fix the problem. What we know about the social science would indicate, I don't know if there has been any reduction in the lineup for the Speaker's Corner in Hyde Park. What the social science would indicate is the people who are lining up will be different on the basis of the surveillance. That there are particularly people making identity claims and more vulnerable groups that are going to find it more difficult to be in a place that is now not merely public but surveyed, because it changes the power dynamic. So that the social science would indicate that the people are different. But whether there's been an actual reduction in number, I do not know.
Okay. We're going to take a break at this point. The law school would like you to know that the security cameras in the restrooms are just to make sure that everyone washes his hands. So it's for your own protection.
That's right.
I'm kidding, of course. The program will resume in 10 minutes at 11 o'clock. Thank you, ladies, very much.
Thank you.
Great.